I'm gonna start this presentation. I think nearly everybody is here that's been expected. So welcome everybody to this afternoon's members online course. It's residential conveyancing update 2024, which sounds like it's going to be really quite an interesting conversation today. And that's obviously with David Keighley, David Keighley Training. I'm Ali Parsons. I'm customer success consultant with Landmark Information Group, who are sponsoring this session today. But firstly, let's look at some housekeeping, and you should see some necessary housekeeping information come up on the screen now. Thank you. So firstly, the online course is one of a number of training courses and events that are available from Surrey Law Society. You can see some of the ones that are going to come up in the next few weeks, and encourage you to join if you've not joined any of those that are, good for you, especially the social event, which I know from Landmark's perspective is always a good one to join. So for today's session, should you like to ask a question during the session, can you please do so by using the Q&A box that's on your Teams part, and if you'd like to talk to David directly, can you please use the raise your hand piece on the same Teams piece, so that David can talk to you and we can unmute the microphones. And David has agreed that he's happy for you to speak to him through the session, or either that or you can wait till the end. There's going to be a 5-minute break at about 1 p.m. And just so that you're all aware, this session is being recorded and will be made available to members after the event. And Surrey Law Society have asked that they say that they're extremely grateful if everyone could complete a feedback form, which will be sent with the recording. I'm going to just take this opportunity for a quick update about Landmark Information. So Landmark celebrated its 30th anniversary this April. And over these many years, of which I've been with them for half of, we've built our experience through working closely with real estate lawyers and property conveyancing professionals like yourselves to ensure that we provide you and them with accurate and relevant land and property data. Alongside this, we really do take a dedicated personal approach to support the transaction risk and due diligence process, and that we get involved in anything that's perhaps a little off skew from us so that we understand it fully. So sessions like today are really important to us. Our data, reports and software services are in line with the Law Society, SRA and CLC requirements. On top of that, I just wanted to point towards our training that we provide, and that's on all things environmental, and we can do that through the Landmark Academy, as well as in-house training or webinars. And apart from environmental, the good old standard contaminated land, we also now are very much in line with the climate change sustainability issues that are there and that are becoming part of the legal sector. We recently announced a partnership with carbon action specialist Net Zero Now to support businesses across the property sector in their pursuit of sustainability success. So by combining our two expertise and resources, we're not only helping to help you reduce carbon footprint, but also foster a broader culture of environmental responsibility in this sector. So this partnership, is going to allow us to not just talk about sustainability, which we've been very good at up to now, but also provide a resource to help you all start reducing your own greenhouse gas emissions now, and everything that needs to be explained as part of that. But less about me and more about this session. So this insightful session explores the ever-evolving realm of residential property law, led by the renowned expertise of David Keighley, who's former head of residential property at a Legal 500 firm. It's going to delve into recent case law, practice guides, and the latest industry developments, which I'm sure we're all keen to hear about. So, David, let me hand over to you, and you can introduce your session agenda and present it to us. Thank you.
Thank you. Okay, hopefully you can all see the slides. Oh, that doesn't appear to be working. Hang on a second. There we go. Right. Hopefully you can all see those slides okay. Don't know quite why that didn't work the first time. So as was said earlier, my name's David Keighley, and a number of you have heard me speak before, but so my ugly mug, you don't need to see that any more than necessary. Just by way of background, I was admitted as a solicitor in 1982. And spent my pretty much my entire full-time career until I retired from full-time practice in 2016 with residential conveyancing, finishing off as partner and head of residential conveyancing at Harrington Carmichael. And since then, since retiring from full-time practice, I've now spent my entire time concentrating on lecturing and other related activities. And I lecture from the perspective of a practitioner because I still remain at heart a practitioner. I make no claims to be an academic because I'm not, and I lecture from a practical perspective, and the notes that I've prepared are written very much from the perspective of a practitioner and intended to be usable rather than just being something to shove in the corner and never be looked at again. As I said earlier, I will take questions through the session if necessary, but we'll see how things pan out. So what we're going to be covering today is the bits that I've put there, which is, sorry, hang on a second, my slides have disappeared. Not sure what's going on here. A second, there we go. I'll be covering the revised TA6 and material information, though I'll be concentrating more on the material information rather than the TA6 because of the controversy surrounding that. I will also be working on the material information. Bear me a second, these slides keep disappearing from my screen. There we go. I'll also be working on looking at the proposed protocol for exchange and hold to order. A quick run through the new planning and building regulation enforcement regimes, Building Safety Act, and various problem practice areas. Sorry. So starting off then with the property information form and the TA6 and the material information. Let's just put this into context that material information, although it's very much a topic of the moment, is not new because the estate agents have since 2008 been under an obligation not to omit material information from their property listings. The big issue, however, is that there was no real consistency over what exactly was considered material information. And as a result of that, the information that was being shared by the estate agents was far from consistent. And so as a result of that, Trading Standards decided to issue a revised guidance setting out exactly what was considered material and what was not considered material. And as a result of that, the Trading Standards produced a new guidance during the course of November. Sorry, my clicker wasn't working for a minute. November 2023. And so essentially from November 2023, agents were given a lot more guidance on what was supposed to be provided. Now, the reality is that it's the estate agents who have the primary responsibility under the Trading Standards guidance. And estate agents are told by the Trading Standards guidance that they should be being proactive in actually checking that they have the relevant material and that they should be actively requesting the material and verifying the material which is required by the material information guidelines. And part of that is suggested that they use questionnaires, one of which of course was suggested to be the TA6. Now let's just look at this in a bit more detail as to exactly what is meant by material information, following on from the guidance. Essentially, it's split into three categories. Part A information is information that is always required regardless of circumstances. So this information will always be required to be on the particulars, and these are the council tax bands, the asking price, and the tenure of the property. They think that would be relatively straightforward, but the tenure aspect is one that I suspect is going to result in some interesting information being disclosed, because we'll all be that's new. At the moment, agents have been required to provide details of lease. If it's a leasehold, they should be saying what the leasehold is, but quite often you'll see that it says something along the lines of well, we've been told, or we understand that the lease is X number of years remaining and the rent is whatever. Under the guidelines, they are now required to verify that information, so it shouldn't be possible, although I dare say they might continue to do so. It shouldn't, in order to comply with the regulations, they should not say that we haven't verified this information. And it goes to the extent to which the trading standards have put the onus on the estate agents is such that they say to the agents, well, you should also be checking the boundaries on the ground. So to ensure that the boundaries on the ground are roughly in line with the boundaries on the title. Now, I suspect that is something which just simply isn't happening up to now. It hasn't happened up to now, and I would be very surprised if it actually happens in the future. But that's the sort of onus that trading standards put onto the estate agents. Now, Part A information is always required. Parts B and C information, the trading standards acknowledge is likely to require the engagement of a conveyancer or surveyor, or the trading standards point out the estate agents can offer the services themselves, and it is recommended that the agents liaise with solicitors and with surveyors and indeed their client to ensure that the information that they are providing is correct and has been verified. So material information Part B is information which is required to be established for all properties, but is only considered material if the information will involve some cost of maintenance or repair, affect mortgage availability, affect the enjoyment of or use of the property, or impact on insurance. Now, the reality is, of course, that this is going to require a subjective decision to be made. So the information is going to have to be collated, and then there'll need to be a subjective decision made as to whether the information does fall into one of those categories and therefore is considered material and needs to be disclosed. So let's have a look at what is within material information Part B. Essentially, it is the physical characteristics of the property. So property type, well, that's relatively straightforward, isn't it? Materials used in construction. Now that's somewhat more complex. And say estate agents are not generally qualified to advise on the nature of the materials used in construction. And I suspect in some cases, neither will the clients themselves be that particularly clear on exactly what sort of materials are used in construction. Now, there may well be some local factors at play here. For example, I now live and practice very part-time in Cornwall, and there are some properties here in Cornwall which are considered unmortgageable by virtue of the materials used in their construction. Essentially, there were properties built using materials which were partially included waste materials from mining, and known as Mundic construction, and the concrete used in those in that construction using the waste materials is not particularly satisfactory, and so lenders won't touch it. Now, agents are aware of this, and so that for some years has been noted and marketed on particulars as saying suitable for cash purchases only. So yeah, whether that will expand out depending on other parts of the country, we don't know. But yeah, to what extent is this going to be picked up is indeterminate. I mean, for example, I say I do practice now still part-time, and I've had a transaction recently where, or with the firm, not me, but the firm had the transaction where the client's survey threw up that the extension had been built at the property, had been built using single skin construction, which was not generally considered suitable for mortgage purposes. Now, obviously, that's something which, on the face of it, ought to have been disclosed if we get material information had been fully up and running when that property was marketed. Then that should have been disclosed during the marketing process. Well, the fact is, in this case, the sellers weren't responsible for the construction of the extension, and so there'd be some doubt as to whether they were actually aware of the nature of its single skin construction. So, whether it would actually be reviewed and would actually only be thrown up when the buyer has their own survey done. It's a question of conjecture. Also, the number and types of rooms, well, that's relatively straightforward, isn't it? And then down to utilities. Now, the utilities drill down into not just the normal water and power, etc., but right down into broadband and mobile signal signal coverage. Now, that is going to be material for some people, perhaps less so for others. I mean, obviously, if you're going to be running a business from home, then the broadband signal or the mobile signal might be more appropriate or more of a factor for you than if you're just somebody who works elsewhere and uses the internet at home occasionally just for email and looking at the BBC or whatever. So essentially, what's material for one person may not necessarily be material for another. And parking is considered material. And this again will be a factor that will need to be disclosed if, for example, there is no parking available. Now, I know that from practicing and dealing with properties all over the country, that particularly in built-up areas, particularly in central London, that there are properties, developments where there is no parking on site at all. So flat developments with no parking. And not only that, there's a Section 106 agreement sitting alongside the development, which says that the residents on the estate may not apply for a residence parking permit in that particular local authority area. Now, again, that's something which would be relevant to a number of people, and so which would need to be disclosed in the sales particulars. Now, again, the issue here is that we're relying, that the trading standards guidance appears to rely on the sellers and the estate agents having the detailed knowledge and to drill down sufficiently into the detailed information to know about the existence of the Section 106 agreement and to understand its significance and to incorporate that in the particulars. Again, I dare say the buyers would have been told about it when they bought, but the sellers would have been told about it when they bought. But as you and I know, of course, everything that sellers and buyers are told during the course of a transaction, they immediately forget as soon as they move in. So, yeah, it's not necessarily going to be good enough to rely on the memory of the seller. Part C information is again a different category, further category. And in this case, it says it may or may not need to be established depending on whether the property is affected by the issue in question. Well, as I see it, until you've established whether the property is affected by it, you don't know whether the information is relevant or not. So I think this is always going to have to be established, but it'll only have to be revealed if the issue is relevant. Now, the information that is considered relevant in Part C is building safety. Now, we'll be talking about the Building Safety Act in a little bit more detail later on. But here we are effectively relying on the sellers and the agents to be able to determine whether the property is impacted by issues which might impact on building safety. So one of the questions in the now postponed TA6, more on which later, was, are there any building safety defects, which might be a fire hazard or might require remediation, and if so, has the remediation been carried out? Well, again, in many cases that will not be relevant, but in some cases, of course, it will be relevant. But whether the sellers would have the ability or the technical knowledge to be able to answer that question and to provide the information is again debatable. And then we drill down into disclosing what restrictive covenants are on the property, and whether they impact on the use or enjoyment of the property, and also what rights and what easements are in place, whether the property has all the relevant rights it needs for its enjoyment, or indeed whether it's subject to any rights or easements in favour of adjoining properties. And then flood risk and coastal erosion risk. Well, coastal erosion clearly is going to be geographical. Flood risk is rather more endemic, and that's something which ordinarily would be picked up in a search. But the sellers are going to be required to disclose if the property is in a flood zone. Then that's something that the sellers will need to disclose, or the agents will need to disclose, sorry, in the sales particulars. Now, that may of course be something which a seller may prefer that a buyer doesn't find out until they've actually made an offer on the property, but you have to wait and see how this beds in. Also, they're required to disclose whether the property is affected by any planning permissions or proposals for development. Again, this may be something that the seller would rather not disclose to the prospective buyer before they've even had a chance to get them around to have a look at the property. But again, this is information which, according to trading standards, needs to be disclosed by the seller and by the estate agents up front, so that the buyer can make an informed decision, as indeed is information about whether the property's had adaptations to make it more suitable for disabled access, and whether the property is in coalfield or mining area. Now, as you'll see, there's a great deal of detailed information there that trading standards say needs to be collated and incorporated within the sales particulars. Now, the trading standards have acknowledged that agents are not experts in these fields, and that they are not necessarily able or qualified to make judgments, as it says, particularly on building safety or interpreting title documents. And it's therefore recommended that the information is sought by seeking the services of a solicitor or a surveyor. Again, you can see that the trend here is that these trading standards aim, I suspect, is to try and encourage sellers to engage, with solicitors while the property is on the market, or even before the property goes to market, so the issues that might be relevant can perhaps be identified before the property goes on the market and be dealt with during the marketing process. Now, whether that's actually going to take off in the way that trading standards would like is very much going to depend on the attitude of the home selling public. Now, from my own experience in practice, I mean, certainly way before HIPS was even thought about, I went through a phase with my team of writing to people who've got their houses on the market, offering to get all the information that's required for a contract pack ready while the property was being marketed, so that as soon as they found a buyer, we were ready to hit the ground running. Well, yeah, this was done over a period of 6 to 9 months or so, sent out several hundred of these letters, and not a single instruction was received prior to the properties actually being going under offer. So, I mean, that was a long time ago, but it did to me demonstrate that sellers had no real appetite to engage in the process before the property was actually sold. And certainly were, and this is anecdotal evidence now, talking to practitioners as I go around the country lecturing on this, and their engagement with estate agents, that sellers are incredibly reluctant to incur any cost before they actually know that they've got a buyer for their property. So there has to be some real doubt about to what extent this is actually going to embed in the way that trading standards has envisaged. Now, that said, it's fairly clear that trading standards have delegated much of the responsibility for this to the property portals, so to Rightmove, Yopa, and to the other portals. And I'm aware from a presentation made by Rightmove last month that the intention is that everything which is in categories A, B, and C will be capable of being uploaded by estate agents onto the Rightmove listing and be seen by prospective buyers by clicking on various links within the Rightmove listing. Now that's all well and good for Rightmove to offer that facility, but of course it's whether it's actually going to be useful or usable or even used is going to depend on the extent to which the sellers and the estate agents upload the information. So yeah, watch this space on that one. Now also we have, as we're all aware, of course, the Law Society reissued the TA6, which is a matter of great debate at the moment. And essentially what the Law Society did was take the existing TA6 and take everything that the trading standards said ought to be included in categories A, B, and C, and dumped it within the TA6. Now, as you'll be aware, hopefully the TA6, the compulsory introduction of the TA6 for CQS firms has been postponed. The form, however, just to stress, has not been withdrawn. It's still available for use, and the Law Society still appear to be encouraging people to use it. Now, certainly my experience talking to practitioners around the country is that hardly anybody is actually using the form and probably won't do so until they're actually forced to do so. Now, as we know, the Law Society have postponed it until June, and then effectively until January. Sorry, it was supposed to come in yesterday, and the Law Society have postponed it now, but they have made it clear that their intention is still to introduce the form in January of 2025. And in the meantime, they are going to go through a period of consultation, which is supposed to be launched during the course of next month. And also next month, as many of you will hopefully be aware, there is the special general meeting at which the motion of no confidence in the President and the Chief Executive of the Law Society relating to their handling of the TA6 is going to be discussed. Now, the TA6 itself is effectively, we know, is a protocol form. So for a CQS firm, it is compulsory. What was not clear by the previous now aborted introduction of it is whether, for example, it would be necessary to complete the form in its entirety if the information had already been provided by the estate agents and the sellers in a different format when the property went on the market. Because the TA6 was split into two, the proposed TA6 was split into two, which was part one, which was all the material information that trading standards said was required, and part two was the existing TA6. Now, again, I think what needed to be done here was the protocol really desperately needed to be amended to make it clear whether, for example, if the information that's in part one of the TA6 had already been provided by the estate agents and the sellers through a different format during the marketing process, whether, assuming that the seller solicitors were only actually instructed once the sale has been agreed, and I suspect that will still very largely continue to be the case, whether in that instance the seller solicitors needed to get the seller to complete part one of the TA6, effectively to duplicate the information that had already been provided. Now that clearly needed to be clarified within the protocol. The Law Society within the FAQs, which I shall be referring to later, one of the points which they did raise was that they thought there would be some need to amend the protocol, but they said they weren't going to do anything about it until they saw what happened in practice, which to my mind was a completely wrong way of doing it. Effectively, cart before horse, basically see what everybody does and then we'll amend the protocol to reflect what everybody is doing. Of course, in the meantime, there would be complete confusion as to whether the part one needed to be completed if it had already been provided in a different format. So yeah, that desperately needed to be clarified before the form was introduced. So that's certainly something which I will be engaging with the Law Society in the consultation to suggest that the protocol needs to make it clear the extent to which the form needs to be used, if indeed the information has already been provided in a different format at a prior date, and possibly even saying let's having two versions of the TA6, one which will be used if the seller's solicitors are instructed before the property is sold, and one which is used if the solicitors are instructed only after the property is sold. But we'll have to wait and see what the outcome of the consultation is. But just scrolling through the TA6 itself, the proposed one, I'll have to wait and see what comes out. Basically included everything that the property, the trading standards said should be included in the property in the material information. So all the various categories that I covered in categories A, B, and C, with some additional questions as well. The Law Society tweaked the Japanese knotweed question, which again, this question itself was a bit controversial, in that the question now asks whether there's knotweed abutting or adjoining the property. Well, again, that's going to rely on individuals knowing whether there's knotweed on their neighbour's property. But and also the question there is what exactly is abutting and what's adjoining. So again, some potential areas for confusion there. Now, as we know, the form was criticised very heavily, largely over the lack of consultation and over the content of it, and the question marks over its correct use, and also the fact, of course, that CQS firms will be obliged to use it, but CLC firms who can't be members of CQS would not be required to use it. Now, following the postponement, the Law Society issued an FAQ before, but they updated it after the postponement. Now, I'm not going to go through all of the points in the FAQs, so I'm going to pick out some of the key points. If you want to look at the whole thing, then you'll find the FAQs, that link there on the slide. So look at this. This is one of the questions. Will the sellers be able to respond to questions about these matters? It's obviously following on from questions of discussions about what exactly was material information. And then the response is, again, vague. Sellers do not know. They're not obliged to respond. So effectively, if a seller doesn't know, then according to the Law Society, they should just simply leave it blank, which again shoots in the foot the whole purpose of material information in the first place. And then does actually point out that sellers should supply information from their own knowledge. And then the other question was, if sellers can only respond using their own knowledge, how much should I help them to complete the responses? Again, presupposing that you were instructed while the property was being marketed. And again, the response to the Law Society was, well, we should carry on pretty much as we have been doing up to now, which was to advise the clients in accordance with the instructions to sellers at the front of the form. And then another question, which was, what's now the legal position for seller solicitors? Now, this was prompted by a concern that solicitors providing the information within the TA6 and the material information within the TA6 could be exposing themselves to additional liability. Now, the Law Society take a fairly hard line on this, with which I do not actually wholeheartedly, or indeed in some cases entirely agree. But effectively, the Law Society's view is that there is no additional liability on a seller solicitors because of the use of the TA6 in its proposed new form. They do, however, acknowledge that there might well be standard liabilities, potential liabilities under contract or tort, or as a result of the retainer. Now, so I'm not entirely convinced that that is a line which is correct, and I suspect will become under challenge during the consultation, particularly, and this is a real concern that many people have, about whether the TA6 actually increases the risk of criminal offences. Now, the criminal offences aspect is because of the unfair trading regulations, more on which in a second. Again, the Law Society say that they do not believe that there is any liability, any potential increase in criminal liability potential for solicitors from the new form. They say, having taken specialist advice, it's now become apparent that they took that advice in 2016 when they issued a guidance note in relation to the consumer protection from unfair trading regulations. So this is not specialist advice that they've taken just recently as a result of the revised TA6. So effectively, let's have a look. What are these consumer protection regulations? Well, they've been in place since 2008. It took 8 years for the Law Society to issue a practice note about the impact on conveyancers. But the practice note itself did actually make it clear that if solicitors were to infringe the consumer protection regulations, that they are potentially committing a criminal offence which is liable for a fine or term of imprisonment not exceeding 2 years. So, not a very pleasant prospect. So let's have a look at what in reality is the likelihood of criminal liability on solicitors arising from material information. Well, the consumer protection regulations say that material information is information that the average consumer needs, according to the context, to take an informed transactional decision. And the test is whether omitting to disclose material information is likely to cause the average consumer to take a transactional decision that they would not have taken otherwise. So there's a degree of subjectiveness in that. Now, the Law Society appear to be relying fairly heavily on the basis of the case of Office of Fair Trading against Purely Creative from 2011, which essentially said that what a purchaser needs has to be understood in its proper context and needs to take into account the fact that sellers can rely on caveat emptor and that solicitors owe a duty of confidentiality. And therefore, the Law Society's view is there unlikely to be an omission of material information and therefore a breach of the CPRs if a solicitor fails to disclose information which is either confidential or falls within caveat emptor. Now, this is a grey area, I think it's fair to say. I have to say, I still think that the potential for criminal liability is still there. It's always there as a part of the consumer protection regulations anyway. But yeah, I have concerns as to whether using the TA6 and the information in the TA6, if the solicitors are deemed to own and to give that information out, that they may be held liable to it. So to some extent, this is an area which will still need to be tested because the law in this area is entirely unclear. But let's have a look. Misrepresentation. I mean, a seller who completes a TA6 form could be found liable in misrepresentation. Well, that's no different from the current TA6 form because the new TA6 form, as it's significantly expanded, does give the scope, gives potential scope for a greater number of claims under the Misrepresentation Act, resulting from incorrect information in the TA6. Let's just remind us what Section 1 of the Misrepresentation Act says. Essentially, if you make a representation which is untrue and somebody acts on that and makes a purchasing decision, then they might be able to make a claim. Now, they've got to be able to prove that an actionable representation was made, one or more of those representations was untrue, that they relied on it when entering into the contract, and as a result suffered loss. So there's quite a high hurdle to cross over before being able to claim in misrepresentation. But it's there, it always has been there, and I suspect it will be increased if the TA6 form is used in its current format. Now, the TA6 itself does actually contain a very clear warning to clients about the need to ensure that the information provided is accurate. And in that regard, I think it will be important if the form is, or when the form is introduced, because we know it is going to be introduced, but we just don't know in what format, is that clients ought to be referred to the explanatory notes. Now, this is not just the commentaries within the form itself, but is a separate form which sellers are given more detailed information about how to complete the form and what should and should not be included within the answer. But that link is available there on the slide. It's probably worth having a look at that. The explanatory notes themselves are nearly as long as the new form. And so there is a concern really as to the exposure of solicitors. So it's a matter for individual firms to determine, and we might have to wait and see what comes of the consultation, of course. But it might well be worth pondering whether disclaimers would be usable, and to what, because we don't know to what extent disclaimers would actually stand up in a court of law. But it might well be worth thinking about putting in your terms of business a clause making it clear that the sellers are responsible for the information contained in the TA forms. And also that when you send out the TA forms, making it clear that as a firm, you don't accept any liability for the client's replies on that TA form. They might think, well, does misrepresentation ever arise as a result of the property information made available and by the seller? Well, the case of Rosser against Pacifico actually turned entirely around the questions in the TA6 answers given to the TA6 in its current or in the previous format, now the 4th edition format. The property was sold and marketed with the benefit of 2 bedrooms. One of the bedrooms, the only means of light and ventilation into that bedroom was a Velux roof light window. Now, there was no consent for the Velux window, which was needed because the property was in a conservation area, and the seller answered no in the question in the TA6 about whether they were aware of any breach of planning permission or had carried out any work without the necessary consents, etc. Now the transaction went ahead, and Mrs. Rosser, after completion, received a letter from the council notifying her that the roof light was unauthorised and that there was potential enforcement action, and as a result of that, she had to remove the Velux window, meaning that the room could no longer be used and let as a bedroom. Now, the property was bought on the basis of it being let as a 2-bedroom property. It could now only be let as a 1-bedroom property, and therefore Mrs. Rosser claims that I have suffered a loss as a result of the misrepresentation within the TA6. Now, to what extent that information should have been verified by the solicitors during the course of the transaction is of course a subject for discussion. But it was interesting to note that in its judgment, the judge found that the conveyancing process operates on the basis that the buyer is entitled to ask questions of the seller rather than having to make their own inquiries, and that a buyer is entitled to rely on the seller's answer, as the seller has greater knowledge about what has been done to the property and with what permissions. And also the court basically said that the sellers should make their own reasonable inquiries before answering questions, and rather than just blindly saying, no, don't know, whatever, and that the answer no in the form carried with it the implied representations that the defendants, so in this case Pacifico, had reasonable grounds to believe that there was no work carried out which didn't have the necessary consents, and that Mrs. Rosser was entitled to rely on that. As a result, she was entitled to significant damages arising from the misrepresentation given by the seller in the TA6. Now you see that was on the old TA6. The new TA6, the proposed new TA6, I think has far greater scope for that sort of misrepresentation to occur. Now, whether and if that's going to happen is, of course, unclear, but the risk is very much a live one. I'm just going to pause at that stage to see if there's any questions or Q&As that come up as a result of that. No, it doesn't appear so. So let me look in the chat box. No, okay, nothing there. Okay, so we'll carry on with the next session. So what I'm going to be talking about now, before we take the break, is the proposed new exchange protocols. Now, the Law Society did carry out a consultation on this, which has now closed. and the Law Society are now considering the responses to the consultation. But essentially, what the Law Society are proposing is to introduce a new draft exchange and hold to order protocol containing 3 individual and distinct protocols. First one relating to the holding to order of documents or deposits. The second one relating to immediate exchange, and a third one relating to release of contracts. Now, the exchange protocols are variations on the existing exchange formulae, but the holding to order protocol is a completely new one. Holding to order is something that, of course, we've all been using for many, many years, but up to now, there is actually nothing in place to regulate what exactly is meant by hold to order. There's nothing in the protocol, there's nothing in the standard conditions, there's nothing in the general law. It's just something which has emerged by custom and practice. And so to that extent, the proposed introduction is perhaps welcome, because it will determine and lay down the foundations of exactly what is meant by held to order. So let's have a look at these in detail. The immediate exchange protocol is intended to replace the existing exchange formulae A and B, and the release of contracts protocol will replace Formula C of the current Law Society code for exchange. Now, many of you may be thinking, well, I've never used Formula C, so what's that all about? Well, the reality is that very few people actually use Formula C formally, but in the vast majority of transactions where there is a chain, if we've given a release, you've taken a release on your related sale and given a release on your related purchase, and then exchanged in accordance with those releases, then you've probably recorded that as Formula B. Well, that never has been Formula B. That has always been Formula C. And so the reality is that we've all been mangling Formula B to meet what we thought was our requirements, whereas in reality we should always have been using Formula C for any transaction involving a release. And so the proposal is effectively to regulate and to clarify the nature of the various exchanges by, as I say, replacing the existing formulae with one for immediate exchange and one for release. And I shall look at the details of those shortly. So the general background to this is that the draft of the code confirms that if you agree to use the relevant protocol, that you are then giving an undertaking to comply with that protocol. So essentially, if, for example, in your initial letter to the other side, you acknowledge that you will be using and adopting the codes, the protocols for exchange and for holding to order, then you are at that stage giving an undertaking. And so the undertaking will be embedded and implied in your initial letter. So you need to be careful to make sure that if necessary, that is recorded as an undertaking in your undertakings register. Now, I'd suggest that one way of avoiding you needing to make a note in every single transaction in the undertakings register might be to ensure that perhaps your office procedures manual makes it clear that undertakings under the protocols are routine undertakings, which don't need to be recorded in the separate undertakings register. And the Law Society, the draft actually makes comments on ensuring that only people who are authorised to give undertakings do so. Now, the draft itself does actually bring the protocols and the formulae up to date in relation to the modes of communication. The existing codes do not currently allow for communication by email or indeed by exchange of contracts by email, but the codes do allow, as they stand, for telex to be an authorised method of communication. Now, telex, for those who even know what it is, they'll know it hasn't been in use since the late 1970s, early 1980s. So, it's not something that's particularly relevant. But the new code has effectively clarified and makes it clear that unless otherwise stated or specified, communications can be by email, by letter, or on a shared electronic platform. The code itself, the draft itself, makes it clear that the code is not automatic for all firms, but the code itself, the draft did say that it would be automatically would be imposed, on CQS firms, and so it would effectively become embedded in the protocol. And if the code is adopted, which as a CQS firm, if it's adopted, if it's introduced in its proposed format, then as a CQS firm, you'll have no option but to do so. You will be required to confirm the adoption of the code in writing, and that confirmation will constitute an undertaking to comply with the code and perform your respective obligations under the code, which is the point I made earlier about ensuring that your initial letter, if it gives the confirmation, is regarded as an undertaking to that effect. So let's have a look at what these various protocols, how they break down. So the hold to order protocol, say, is the new one. If documents are being held to order, so if you send a document, if I'm the seller solicitor and I send to one of you a document to be held to order, then assuming we have agreed to adopt the code, then you as the receiving solicitor are giving me as the sending solicitor an undertaking that you are, as the receiving solicitor, you are holding the document, but in reality it still belongs to and is under the control of me as the sender's solicitor. So whilst you've got physical possession of the document, control and constructive possession of the document remains with me, and that you will not actually do anything with it or amend it or date it or do anything with it until I authorize you to do so. So, I mean, that just makes it fairly clear that, the basis on which the document is being held to order. Now, to what extent documents are being sent to hold to order is perhaps debatable. I think like any examples of maybe where you might have a large, if you're doing unregistered conveyancing, you might have a large epitome or abstract of title, which isn't very easy to copy or for various reasons can't be very readily copied. Then you might, I suppose, possibly think about sending the original to the other side to be held to order. Again, that just makes it clear that the document would be still yours as the senders, and that the buyers would be responsible for dealing with it as you suggest. But yeah, I think that the intention behind it was probably more in relation to contracts, although to what extent people actually send contracts to the other side to be held to order is perhaps debatable. The more likely impact of the hold to order protocol, however, is going to be in respect of money. So here, again, the protocol dictates that if you as the sender of money send money to another solicitor, so let's imagine that we've got a complete, we're doing a simultaneous exchange and completion, and we haven't yet exchanged, so I send you the money to be held to order pending the exchange and simultaneous completion. But in that situation, the protocol dictates that I, as the buyer solicitor, send you the money. So you, as the seller solicitors, are holding the money. But as with the documents, the money still remains under the complete control and constructive possession of the person who sent it. So if I send you money, whilst you physically got the money in your bank account, the control of that money and the constructive possession of that money still remains with me, and that you will not do anything with it unless I tell you and authorize you to do so. So that would make it clear in that situation that if there is a transaction such as that I send you the money to be held to order pending exchange and completion, you cannot then send on that money to the other side on any related transaction unless I have previously authorized you to do so. Now, the protocol in respect of parting down of money also drills down in relation to deposits, which I suspect is where primarily holding to order will take effect. And essentially, if we've got a chain where the deposit money is being passed up through the chain, then the holding to order deposit passed on protocol will apply. Now, in this situation, imagine we've got a chain of three. So you've got a buyer represented by, first-time buyer, bottom of the chain represented by solicitor A, solicitor B in the middle, who's representing the seller to A, and also buying from solicitor C, and solicitor C is acting for the seller of that property, and that's as far as it goes. So we've got three people in the chain. So if on the exchange, setting up the exchange of contracts between solicitor A and solicitor B, if it's agreed that solicitor A will hold the deposit to order, then solicitor B can use the deposit on their related sale, but only, and then various undertakings will kick in, but only if the solicitors say that they are holding the money to order further down the line. So essentially, in this situation where we've got A, B, and C, solicitor A is deemed to undertake with B solicitor to hold the deposit on the terms of the protocol. Solicitor B is deemed to undertake with solicitor C in respect of the money held by A's solicitor, but that will only kick in if B solicitor discloses to C solicitor that they are not actually holding the money and that it's being held by A's solicitor. So if I'm now solicitor B, if I agree with solicitor A that we're going to be solicitor A is going to be holding to order, I then go away and do my exchange with solicitor C. If I tell solicitor C that I'm not physically holding the money and that it's being held by solicitor A, then essentially solicitor A, I'm then holding the money to the order of C solicitor, but the money is the money held by solicitor A. If, however, I do not tell the solicitor C that I haven't got the money, then I am deemed to be holding the money, and I am responsible to solicitor C for the money as if I was actually holding the money. Now, the reality here means that if there's going to be deposits passed up through a chain, that you're going to need to make sure that during the course of the transaction, you have agreed and made it clear that you will not actually be holding the money being used as the deposit and that it's going to be held elsewhere in the chain. Otherwise, you will be deemed to be holding the money and to give a direct undertaking in respect of money, which in reality, you're not actually holding. So that's something which I think is going to have to be embedded into procedures leading up to exchanges once this new code has been introduced. Now, all of the codes make references to as soon as practical. That in reality means on the same day. So there is a bit of a get out for if it's not reasonably delays and not reasonably avoidable. So if, for example, it's the exchange is at 5 o'clock and you can't actually get the contract out in the post that day because it's already gone, then yeah, that would be fine for the next day. But otherwise, whatever you say you're going to do under the terms of the codes, the practice protocols rather, you will be required to do on the same day. Now, there are general points that should be agreed beforehand. Much of this is very similar to what's probably being done already in practice. You should agree before you get to the point of exchange the way in which you're going to exchange, whether you're going to use an electronic copy, whether you're going to use a hard copy. If you're going to be using an electronic copy, how it's going to be signed. Is it going to be secure electronic signature or on-screen writing, or however it's going to be done? And if you are going to be using an electronic contract, it's suggested that you make an agreement that the contract does not come into force at the point it is signed electronically, and that only actually becomes effective at the point of exchange rather than at the point that the contract is actually signed electronically. And then there are various preliminary issues that should be agreed before you get to exchange, pretty much the same as we do now, that you should agree the names of the who's going to be doing the exchange, your undertaking that you are actually authorized to exchange and that you are holding the relevant contract, and that also you agree that what's going to happen to the deposit. So again, that's not too dissimilar to what we have at the moment. So the immediate exchange protocol, looking at that, effectively the immediate exchange protocol is if you've literally just got a sale and a purchase with no onward chain. So essentially at the point of exchange, the contract becomes effective, and the solicitors are then giving each other an undertaking that they will date the contract and do whatever has been agreed we've written into the contract. And that the contract is then held to the order of the other solicitor. So I'm now holding, if I'm the seller, I'm now holding my seller's contract to the order of the buyer's solicitor and vice versa. And that I also say that I will comply with the post-exchange obligations. Now, the post-exchange obligations are to pay the deposit if that's what's been agreed. And if the contract is going to be formed on paper, that I will send you the paper contract as soon as practical, which bear in mind means on the same day, and that I will also on the same day send you an email of the contract. So if the contract is going to be made in paper, I have to send you an email of the exchange contract, and then follow up with the actual hard copy in the post or where it's still being used, the DX. Now, whether that particular aspect will survive the consultation, we'll have to wait and see. The release protocol makes it clear that solicitors do not, as a matter of law, have applied authority to release contracts for later exchange. And it is therefore a requirement for use of or not a requirement, but it's a recommendation, a very strong recommendation, that if you're using the release protocol, that you should ensure that you have the authority of your client to do so. Now, the protocol draft does actually set out a release protocol authority, which I've put on this slide and the one which follows. I think this is pretty critical, particularly the third bullet point there, because essentially making it clear to a client that once they have given the authority to exchange, it can't be withdrawn, and that's actually realized or reinforced, by the bullet point on this second slide. Effectively, the client is authorizing you to use the release protocol, but also acknowledging that once the client has given you the authority to exchange, then they cannot revoke it on the day that has been done. Now, you might think, well, is this an issue? Well, it's something I have actually experienced once in practice, where a client did give me authority to exchange. So I went ahead and gave the release on their purchase, and about 25 minutes later they called back to say that they'd just become aware that there was a round of redundancies being imposed at their employer, and that they therefore wanted to put their sale and purchase on hold. Now, of course, I'd already given a release of the contract, and so the question rather begged, if in the meantime the sellers who had taken the release had gone ahead and done the exchange on their related purchase and were then, were in the process of coming back to me at the same time. Example, I was on the phone to my client. Would my client be able to withdraw from the transaction and remove their authority? Well, that way it's unclear under the current protocols, but this makes it abundantly clear that once the client has given the authority, they cannot revoke it on that particular day. Now, that's also very important because essentially when you use the release protocol, you are actually confirming that you're holding the contract, etc. But you are also irrevocably authorizing the other party to exchange contracts on that day, and that you will not revoke the contract or the release on that day. So because you as the solicitors are giving an irrevocable undertaking, an irrevocable authority, to the solicitor above you, you need an irrevocable authority from your client. So it is going to be very important to make sure that you do have this authority signed and in place before you use the release protocol. And then the release protocol, using it also requires that you stipulate the method by which you will be communicating the exchange, so whether it's going to be by telephone or by email or whatever. If it's by telephone, then you need to ensure that you or at least one other named person will be available to take the telephone call until the stipulated time for exchange, and then the the purpose of the process of exchange is exactly the same as the other one. You take the contract and you insert all the various bits and pieces in it that you say that you will do. So again, those remain pretty much the same as they are at the moment. So conscious I whistled through that because there was a lot to get through in the hour's break, but it's now 1:05. So I suggest that we now take a break for 5 minutes just to allow people to refresh their glasses or do whatever, and then we'll carry on with the rest of today's programme. And again, I'll pause before starting to see if there's any more questions about the protocols, etc., before we move on to the next section.
Thanks, David.
So cracking on from where we left off, I'm going to be talking now about the revised planning enforcement regime. The time limits for enforcement of planning breaches changed on the 25th of April, so just a couple of months or so ago. That was done by the bringing into effect of various commencement regulations under the Planning Act and the Levelling Up and Regeneration Act of 2023. The impact of those enforcement of those regulations was to increase the time limits for enforcement of planning breaches, so that in England, any breach of planning control is now subject to a time period of 10 years from the date on which operations were substantially completed. But in Wales, it remains at 4 years. So if you think previously we had a situation where in England and Wales, there was a period of 4 years for some breaches, breach of conditions or unauthorised works, or 10 years for example, unauthorised change of use. With effect from April now, that time limit is 10 years for all breaches, irrespective of the nature of the breach in England, and 4 years for all breaches, again, irrespective of the nature of the breach in Wales. Now, the critical thing is that the time limits relate to work completed, substantially completed after the 25th, on or after the 25th of April 2024. There are transitional provisions in place which retain the 4-year enforcement period for certain pre-existing breaches. This is primarily for unauthorised building works substantially completed before the 25th of April of this year. Now, of course, one of the issues here is determining when exactly are works substantially completed, and does that mean that everything's been done, excuse me, and the developers or builders are off site, or does it mean that most of the work's been done? There's just a few sort of finishing off points to be carried out. Again, that's not entirely clear. The reality is that for works which were clearly done, let's say building works which were done 2 years ago, then the 4-year period will still apply if it's breach of condition or unauthorised works. So it's going to be a while before we start seeing the impact of this in practice. But just be alive to the fact that the time period has substantially increased. Now, in addition to changing the time limits, there was a new power introduced for local authorities, and this was the new power to provide what's known as a warning notice. Now, this essentially is where the local authority are aware that there has been a breach of planning control, but for example, if they are aware of a breach of planning control, but they believe that if the person who committed the breach had applied for planning consent, that there was a reasonable permission, that they would have been given permission, then the local authority has the power to serve an a warning notice. Essentially, what the warning notice does is say to the person who's carried out the work, you've done something which you shouldn't have done. It didn't have permission. but if you did apply for permission, then there's a pretty good chance you would have got it. Therefore, we are serving a warning notice on you, requesting that you submit a retrospective planning application within a specified period. And if you don't submit the application for retrospective planning permission, that we are then empowered and able to take enforcement action. So this is an additional power, essentially giving the local authority an opportunity to not go straight to enforcement, but to issue, sort of shot across the bows, as it were, of somebody who's done something, and giving them the opportunity to regularise the position by a retrospective application, rather than being subjected to immediate enforcement action. Now, the planning enforcement notice has various requirements that must be met. It must specify the issue which is apparently in breach, and put people on notice that if they don't apply for retrospective, that they can be subject to enforcement, and it needs to be served on the owner or occupier of the land, or anybody else which the local authority thinks would have an interest materially affected by enforcement action. And issuing an enforcement warning notice doesn't prejudice any other power, so it's an additional power which local authorities can use should they choose to do so. Now, in addition to the planning procedure time limits changing, the building regulations enforcement regime has also undergone a significant overhaul, and this is, as a result of Section 39 of the Building Act being brought into force. Building Safety Act, sorry. So Section 39 of the Building Safety Act obviously was passed at the same time as the rest of the Act, but didn't actually come into effect. And so that part of the Act was brought into force on the 1st of October of last year. So with effect from the 1st of October last year, the time period for enforcing building regulations breaches has increased from 12 months to 10 years. Now, that's obviously a significant increase in the time period that local authorities have available to them to issue enforcement proceedings. Again, this is an issue which will probably become more relevant as time passes, but I suspect one impact of this is that for works which are potentially impacted by the new rules, the indemnity policies are likely to become more expensive. Now, the one question here is it retrospective? Now, the planning change, it was made clear that there were transitional provisions relating to works which were substantially completed before the time limits were increased. We don't have the same clarity in respect of building regulations changes. It's not entirely clear. Now, what's happened, what the impact of the change is to change Section 36 of the Building Act 1984 to say that an enforcement notice must be served within 10 years from the date of completion of the building work that is in breach. Now, when building work is completed is a question of fact. Now, although it doesn't say so specifically in the regulations, in the enforcement, in the regulations bringing it into effect, the commencement notice, sorry, and it's not clear either in the commencement notice or in the section whether it is retrospective, I think we can have pretty confident to say that the 10-year limitation period for building regulations enforcement only applies to work which was completed after the 1st of October 2023. Now, the principal arguments for that are that there is a general expectation that legislation does not have retrospective effect, and that if legislation is intended to be retrospective, that would normally be made clear in the relevant legislation. Now, in this case, the legislation in question is the Building Safety Act. The Building Safety Act did contain sections which were expressed to be retrospective. and those sections is made clear within the Building Safety Act that those provisions amending for example, the Defective Premises Act were intended to be retrospective. But the amendments in respect of building regulations contained in the Building Safety Act do not say that the provision is intended to be retrospective. So I think relying on the principle that unless stated otherwise, it's not retrospective, and given also that the Act does in other places say that the impact is retrospective, I think we can be pretty confident that the change is not retrospective. Now that is also perhaps made a bit clearer in the in the transitional and commencement notices, which basically make it clear that if a notice had been served before the 1st of October 2023, that the provisions in relation to the previous enforcement regime would apply. So essentially any notice which had already been issued will be governed by the previous regulations, but it doesn't say specifically one way or another whether a notice served after 1st of October 2023 in relation to works which were completed before 21st of October 2023, whether that's 4 years, 12 months or 10 years. But I think the reality is that it's not retrospective. The chances are, the very strong probability is that it is not retrospective. But the legislation and the regulations do not provide the clarity that the planning changes do, sadly. But I think, again, this is not likely to be an issue in practice for some little while. But from sort of later this year or from now onwards, really, if work has been done without building regulation approval, it's going to be important to ascertain exactly when the work was completed. Because only once you know when the work was completed will you know whether the enforcement period is 12 months or 10 years. And I can see, for example, the indemnity policy insurers are likely to ask the question, sort of when was the work completed, so that they can assess their risk accordingly. So again, this is something which is inevitably going to impact on practice as we move forward. Pause at that stage just to see if there's any questions pop up on that. I'm not seeing anything appear in the Q&A box. No, okay. So we'll move on then to our old friend, the Building Safety Act. I'm not going to go through the whole of the Act again. I'm just going to pick out some problem areas or some continuing problem areas. But in order to do so, obviously, I just need to set the tone to remind you of some of the key issues and some of the key terms in relation to the Act. Now, the Act itself came into force on the 28th of June 2022, so we're coming up to its second birthday. The Act itself, and to be clear, the Act itself and the protections within the Act only apply if the property is within a building which is more than 11 metres or 5 stories, whichever is first reached. So the critical thing is it's whichever is first reached. So you could have a building which is 4 stories high, but containing 4 stories, but is say 12 metres high. That would be within 10 metres high. That would be within the Act. Or you could have a building which is 12 metres high but only 4 stories, and that would be within the Act. So it's whichever of those two is first reached. And the important thing to appreciate is that there are key terms in relation to the Act: qualifying leases and leaseholders, relevant building, and relevant defects. Now, I've lumped the leases and leaseholders together, although they are actually two separate terms. So for a lease to qualify, the lease must meet these criteria. It must be a lease of more than 21 years, again in a building of above 11 metres or at least 5 stories, and the lessees must be responsible for paying a service charge. Now, I thought that was relatively straightforward until a few months ago when I was asked to give an opinion on whether one particular lease was inside or outside of the Act. The property was within a retirement community, And the way in which the service charges were levied was that once, when you bought the property, the service charge was fixed at a level at the time you bought, and that remained fixed throughout the time that you owned the property. The developers and the freeholders of the retirement community were essentially taking the risk that the amount they were recovering by way of service charge would not be less than the amount that they would expend. If they were spending out more than they were recovering, then according to the lease, because it was fixed, they couldn't increase the service charges until the property next changed hands. Now, as a result of that, the developer was saying that this building is outside of the scope of the Building Safety Act because the service charge does not meet the definition within the Building Safety Act. Now, I had a look at the Act, and the Act says that service charges have the same meaning as in the Landlord and Tenant Act. And in the Landlord and Tenant Act, it made it clear that a service charge has to have an element of variance. So it has to rise and fall according to the amount being expended by the person imposing the service charge. And therefore, because of the fixed nature of the charge on that particular development, it did, in my view, take it outside the scope of the Building Safety Act. Now, that's not something which I suspect will apply very often, but it is just worth something watching out for if that becomes a thing with the service charges in retirement communities. And now the next thing is that the lease must have been granted before the 14th of February 2022, with one exception which I'll touch on shortly. So what that means, again with one exception, is that any new build lease, any lease, shall we say, of a new build property being granted now, is going to automatically be outside the scope of the Act because it is dated after the 14th of February 2022. Now, there is, say, a tweak to that in respect of surrender and regrant, which I shall touch on shortly. And there's also a proviso then in relation to the leaseholder. On the 14th of February 2022, the dwelling must have been the lessee's only or main home, or if they owned other properties on the 14th of February, they must not have owned more than 3 dwellings in the UK. Now, that ignores any dwellings or any properties outside of the UK, and it also ignores any commercial properties because it specifically refers to dwellings in the UK. Now, it is clear that the status of the property on the 14th of February 2022 is going to remain fixed. So if, for example, the property on the 14th of February 2022 was owned by somebody who at that stage was not a qualifying leaseholder because they, for example, owned a buy-to-let portfolio of 5 properties, then all future owners of that property will inherit the non-qualifying status. Now, that's given rise to some anomalies. I mean, if, for example, if I have a portfolio of, let's say, 10 buy-to-let properties, which I don't, but if I did, then if on the 14th of February 2022, if I had a leasehold property in a block which was potentially impacted, then I would not be a qualifying tenant and I would therefore not be protected. If I then sell one of those properties to somebody who's going to be occupying it as their own home, as their only home, then they would have qualified on the 14th of February 2022, but they won't now qualify because they inherit my non-qualifying status. Conversely, if somebody owned the property as their single dwelling on the 14th of February 2022, and they now sell it to somebody who has a buy-to-let portfolio of, say, 10 properties, then the buy-to-let portfolio owner would inherit the qualifying status of the previous owner. So, yeah, it's the status on the 14th of February 2022 is absolute, and it will be inherited by whoever takes on the property from now on. Now, one of the issues in relation to this is the status on the 14th of February 2022 and the lease being granted before the 14th of February 2022. It was acknowledged that this meant that if you did a lease extension by means of a surrender and regrant, if your existing lease qualified under the terms of the Act, then because your new lease was going to be dated after the 14th of February 2022, the new lease would not qualify. That it was acknowledged by government was a drafting error. That, to my understanding, is the only time the government has acknowledged a drafting error in the Act, although there are many dozens of drafting issues and uncertainties within the Act. But government said that they would legislate. Now, before they did so, an amendment was tabled in the House of Lords to correct the error and to effectively say that any lease which qualified on the 14th of February 2022, if that lease had been surrendered and a new lease taken by way of surrender and regrant, then the new lease would qualify even though it was dated after the 14th of February 2022, and that the proposal was to be retrospective. That was tabled in the House of Lords. It was passed by the Lords, but with government opposition. There were 134 Conservative votes on the amendment, and they all voted against the amendment. There was nothing in the debate which indicated why they were against the amendment, so it was clear that this was a whipped operation. The amendment was then passed to the House of Commons. The House of Commons rejected the House of Lords amendment and replaced it with a government-tabled amendment. And what this government-tabled amendment has done has introduced the concept of a connected replacement lease. Now, essentially, if you do a lease surrender and regrant, and your old lease and your new lease meet the criteria as a connected replacement lease, then if your old lease qualified under the Act, then your new lease will also qualify under the Act. Now, say in most cases, that is the most common example of a connected replacement lease will be that, where you surrender a qualifying lease and take a new lease in exchange for an extension of the term of the lease. But what it won't do is resurrect a non-qualifying lease. So if you surrender a non-qualifying lease, then the new lease will remain non-qualifying. The only provision is that if you surrender a qualifying lease, then your new lease will also qualify. And that has been backdated to June 2022. So effectively, any connected replacement leases granted after June 2022 will be protected under the Act if the old lease which was surrendered was protected as at the 14th of February 2022. So that issue has largely been resolved. Now, there are other areas where the uncertainty remains and has yet to be resolved. And one is this, can a company be a qualifying leaseholder? Now, in the Act, it says that for the purposes of the Act, a person owns a dwelling if they have a freehold interest in it or is the tenant under a long lease of it. Now, the Act itself doesn't actually say whether person extends to a corporate body. Now, the Interpretation Act, however, does say that unless an Act makes it clear to the contrary, references to person will extend to a corporate body. So on the face of the Interpretation Act, because the Building Safety Act does not say that a company cannot be a qualifying body, the company is not a person, on the basis of the Interpretation Act, then a company would appear to potentially be capable of being a qualifying leaseholder. However, that's been thrown into doubt by the decision in Triathlon Homes against Stratford Village. Now, this is a fairly detailed judgment, and the critical parts of the judgment, which are obiter sections of the judgment, are in paragraphs 26 and 27. But the impact of those two paragraphs is that the first tier tribunal is essentially indicating that in its view, a corporate tenant cannot have a qualifying lease under the Building Safety Act. Now, I am not convinced that that is correct. Now, I'm of course not uniquely qualified to judge on these areas, but I have also seen opinions published by King's Counsel in which they also agree and argue that the interpretation is incorrect. Now, let's have a look at the reasonings behind that. Essentially, as I said, it's paragraphs 26 and 27 of the judgment. Paragraph 26 is essentially a rehash of the requirements set out in the Act, which is, as at the 14th of February 2022, the dwelling must have been a relevant tenant's only a principal home. They must not have owned more than 3 dwellings in the UK, or must not have owned any other dwelling, or if they did, they must not have owned more than 2 dwellings other than the interest under the lease that they were seeking to be protected. Now, the judgment itself appears to be suggesting that all 3 limbs of that section need to be satisfied. Let's go back. So effectively, the judgment appears to be on the basis that in order to qualify, you need to meet D1, D2, and D3. The arguments being put forward by King's Counsel is that that is incorrect, and that because of the word or after D2, that you can qualify either by meeting D1 and D2 or by meeting D3. So let's just go back. So essentially, if you look at the end of D2, you've got the word or. So on that basis, the current academic argument seems to be that you qualify if you meet D1 and D2, which is that you were it was your only home and that you didn't own any other dwelling, or that you owned no more than 2 dwellings apart from their interest under the lease. Now, one of the arguments that the court made was essentially whether a company could ever meet D1, in the sense of, can a company ever have a principal home? Now, a company, of course, has a registered office, but doesn't have a home in the context of you and I have a home. So on that basis, the court seems to have predicated their judgment on the fact that because a company can't meet D1, it can never be a qualifying leaseholder. But say the academic opinion is that a company could argue that they qualified under D3, even if they didn't qualify under D1 and 2. Now, as I said, essentially, this is the comments were made obiter. It's the first tier tribunal decision, so I think it may well require further judicial decision or legislative clarity to confirm whether or not companies can be qualifying leaseholders. But as it stands at the moment, there is at least a doubt about whether a company is capable of being a qualifying leaseholder. There's also doubts about whether an executor of a deceased leaseholder can be a qualifying leaseholder. It's almost certainly the case, or is felt to be almost certainly the case, that if the deceased died before the 14th of February 2022, that the executors will not qualify, because the executors themselves will, of course, inherit the status of the owner of the property on the 14th of February 2022. And if, let's say, the deceased died on the 10th of February 2022, when they won't have had a home on the 14th of February 2022, and therefore would fall foul of potentially the criteria in section 119. For deaths after the 14th of February 2022, the position that the Act is completely silent. Now, the position here, its academic argument is that it's likely that executors of deceased individuals who died after the 14th of February 2022 will inherit the status of the deceased as at the 14th of February 2022. So if the deceased was a qualifying leaseholder on the 14th of February 2022, then the academic opinion is that executors will inherit that status. But the Act doesn't make it clear. And so that's really just at the moment the academic interpretation of various barristers. I don't believe that it was ever the intention that executors would be excluded from being the qualifying leaseholders. But again, it would have been nice if the Act actually made it clear one way or the other, which sadly it doesn't. There's also a real question about whether trustees or an attorney or a deputy of a vulnerable person, so either an attorney or somebody acting under a court of protection, Office of Public Guardian order. It's also a bit unclear as to whether they would be a qualifying leaseholder. Now, the Law Society and the Department of Levelling Up actually published a section of questions and answers on the Act. And one of the questions and the answers given by government seems to suggest that government's view is that trustees are not qualifying leaseholders. But again, that's not absolutely clear, and it may need a further judicial ruling to completely clarify that. Buildings themselves, in order for the building to be relevant, as I mentioned before, it must be 11 meters in height or has 5 stories, whichever is first reached, and it must contain at least 2 dwellings. And then there is a major exception. Essentially, any building which is leaseholder owned, so any building which has been collectively enfranchised, or where the leaseholders own the freehold of the building through a company, is automatically outside the scope of the Act. And again, information which has come out from government is that in the collective enfranchisement issue, it doesn't matter whether or not all of the leaseholders engaged in the collective enfranchisement, because it basically says in the questions and answer and information that's come out from government that if one or more of the leaseholders have acquired the freehold, then the building is outside the scope of the Act. So if, for example, we've got a block of, say, 20 flats and 12 people join in the collective enfranchisement and 8 don't, then the 8 that don't are taken outside of the Act by the fact that the other 12 have basically acquired the freehold. So you don't preserve your qualifying status by not having taken part in the collective enfranchisement. Now, counting the number of floors in a building is not entirely straightforward. Neither is measuring the height of a building, because for the purposes of measuring the height of the building, it's not the total height of the building that needs to be measured. It's the height of the building from the lowest point on the ground to the top of the finished floor of the top residential property. So essentially, you need to have access to the top residential property to determine where the top of its finished floor slab is and measure from that point down. Now, this is a real issue about determining the height of the building, and there are various other issues as well. Essentially, you don't count any floors for the purposes of measuring the height of the building. You ignore anything which is not residential, and also for counting the number of floors, you ignore anything which is not residential, and you ignore anything below ground. And mixed use buildings, if there's say you've got a shop on the ground floor and then offices in the middle and then residential above, if you've got 2 residential premises above the mixed commercial and retail, then that's potentially within the scope of the Act. But if there's only 1 flat, then it's outside the scope of the Act. Now, the determining of the height of the building is a critical point for the purposes of conveyancing, because lenders have their requirements are predicated on the height of the building. So one of the questions is, who is responsible for determining the height of the building? Now, this has come out in Law Society guidance, which has been published, and also it's come out in the question and answer between Law Society and the Department of Levelling Up that I mentioned earlier. And the Law Society have made it clear in the guidance that there is no search that you and I can do. There's no way that we can search or provide definitive information as to whether the property is in scope or has the benefit of leaseholder protections. And it also, the Law Society say that we need to be very careful about ensuring we don't make representations about information that we have received, and that we cannot categorically confirm that information we have received, particularly in relation to the leaseholder certificate, is actually correct. And the Law Society have nailed the colours firmly to the mast on our behalf here and have made it clear that it is not our role to categorically state the height of the building. or whether the leaseholder protections apply. So it is not our responsibility. We cannot be held responsible, according to the Law Society's guidance, for determining and taking responsibility for determining the height of the building, or confirming for certain that the leaseholder protections will apply. Which means that we will need to be giving some disclaimers to clients when we're sending them reports, more on which in a second. Now, the Law Society also have issued some guidance as to whether firms should indeed be taking on the work under the Act. Basically, the Law Society acknowledged that that is a decision for each individual firm to make, and the Law Society have set out a number of suggestions for how you would assess whether or not you're willing to take on the work. One issue would be to make sure that if you do take on the work, that you make sure you record the number of transactions that you're doing, and that the nature of the buildings, etc., because that's something which is likely to be required by indemnity insurers moving forward. And I think also it is recommended, and I certainly agree with this, that it will be sensible, if you are taking on the work, to include disclaimers to basically make it clear that you can't necessarily categorically confirm that the information you've been provided in accordance with the Act is actually accurate and correct. And the Law Society make it clear they think that we should, if we're taking on the work, consider putting in a disclaimer saying that we can only check, for example, certain aspects of the leaseholder's certificate and the landlord certificate, but we can't verify the contents of that certificate. Now, the certificate, of course, is the one which the leaseholder certificate is the one which demonstrates whether the leaseholder is or is not a qualifying leaseholder. Essentially, it is a self-certified document where the leaseholder answers a number of questions. And the answers to those questions determine whether the property is or is not within the scope of the Act. Now, the issue is, of course, that you and I cannot categorically confirm that the information supplied by the person who completed that form is actually correct. It's self-certified. It has to be completed by the individual who owned the property on the 14th of February 2022, and information needs to be supported by documentary evidence. Now, one of the primary concerns here is the situation where, let's assume that I bought a flat on the 1st of May 2022. Now, on the 1st of May 2022, the Act wasn't in force, so there was no need for there to be a leaseholder deed of certificate provided by the outgoing seller. But if I now want to sell that property, then I will need to provide the incoming purchaser with a leaseholder deed of certificate and the landlord's deed of certificate. But the certificate that I need to provide needs to be completed not on the basis of my ownership, but on the basis of the status of the person who did own the property on the 14th of February 2022. Now, the issue there is, of course, is that what happens if I can't make contact with the person who owned the property on the 14th of February 2022, or if I do make contact with them and they're unresponsive, and indeed, to how much can I rely on the information that's provided? And one of the critical things is, of course, the number of properties that was owned. And there's no realistic way that I can check by carrying out a search, etc., how many properties a particular individual owned on the 14th of February 2022. So, whereas this is the Law Society basically saying that we can't verify, say that we should point out to clients that we cannot verify the contents of the leaseholder deed of certificate, and so we can't categorically confirm that the information contained in it is correct. And I think that has to be doubly so if the certificate is provided by on the basis of the ownership of somebody other than the current owner of the property. So watch out for that one. Now, the landlord certificate is the landlord's counterpart. This is the landlord certificate where the landlord basically says that either confirms that they were or were not the landlord on the 14th of February 2022, and also confirms whether or not they're able to seek to recover costs of remediating building safety defects by way of the service charge. The landlord certificate needs to be supported by documentation as well. But there was a big amendment made in August 2023. Essentially, if the landlord is completing the certificate to say, yes, I was the landlord on the 14th of February 2023, and because of my status, I am not able to pass on the costs of recovering costs of remediating, building safety defects by way of service charge, then the landlord does not need to provide evidence to confirm that. If, however, the landlord completes the certificate to say, yes, I was the landlord on the 14th of February 2022, and yes, I will be looking, or I want to be able to claim by way of service charge a contribution towards the cost of remediating building safety defects, then the landlord has got to produce vast quantities of evidence to confirm their status on the 14th of February 2022. And effectively that drills down into the value of their total holdings of properties on that date, and the value of properties within their portfolio which were qualifying buildings, and also whether or not the landlord was actually responsible for the development or associated with the development. Now, the issue again is that the certificate itself contains a statement which says that if a landlord does not provide a certificate, then there is a presumption that they are not able to recover anything towards the service charge, not able to recover service charges to cover to contribute, to the cost of maintaining or repairing defects under the Building Safety Act. But the regulations and what it says in the certificate differ significantly. The certificate itself basically says to the landlord, if you do not provide a certificate when you're required to do so, and the landlord, there are 5 trigger events, the landlord is required to provide a certificate on the happening of each of these trigger events. The certificate itself says, if, let's say, trigger point 2 applies, so the leaseholder has notified the landlord that they want to sell, the landlord is then on notice and they should provide a certificate. Now, the warning on the certificate basically says that if the landlord does not provide the certificate within that 4 weeks, that they are deemed to be responsible for the defect and cannot seek to recover anything by way of service charge. But the problem here is the word each. If you look at the there, it says the landlord must provide a copy of the certificate on the happening of each of those events. So if a landlord fails to provide a certificate within 4 weeks of being notified of a sale, then according to the certificate itself, the landlord is then locked out from providing a certificate at a later stage. The problem, however, of course, is the word each, and the word each does not mean the first to occur. And so there is a real concern that if a landlord fails to provide a certificate on the happening of one of those trigger events, that they actually still have another 4 opportunities to provide a certificate. And well, again, this has been tested in the courts in Will against G&O. Basically, here we had a non-responsive landlord, and the tenant applied to the tribunal for an order that the landlord produce a landlord certificate. And the tribunal refused to hear the application on the grounds that they had no authority. They had no power to order the landlord to provide a landlord certificate. So yeah, we have now just judicial authority for saying if your landlord is unresponsive and fails to provide a landlord certificate, the tribunal cannot force the landlord to do so, and there is nothing in the Act which enables you to require or force the landlord to provide the certificate. So if you're acting on a purchase where the landlord is unresponsive, you cannot categorically say to the incoming purchaser that you are protected because the landlord has failed to comply with the certificate, because it is at best very, very unclear. Now, the fire safety regulations came into effect last year as well. These go beyond the Building Safety Act. Essentially, these attached to all multi-unit residential properties where there are shared areas to be used in the event of an escape from a fire. Now, it's made clear in the regulations that it's not intended to capture maisonettes where there are no common parts which should be used in the event of an escape from a fire. So in reality, if we've got a pair of maisonettes where, for example, both owners go in through the front door and the downstairs owner turns left or right or whatever and goes into their flat, and upstairs goes up through an internal staircase, then because we've got that common entrance area, that property would be caught by the fire safety regulations. But if each property is accessed through a separate entrance, so ground floor goes in through the door on the ground floor, and first floor goes up through an external staircase, and then enters through a door at first floor level, then that will be outside of the scope of the fire safety regulations. But the reality is that the vast majority of multi-unit buildings are now within the fire safety regulations. And these regulations require that there is an evacuation plan in place, and fire safety instructions are put in place in relation to how to report a fire and what to do in the event that a fire breaks out. And this information needs to be provided to all incoming residents as soon as reasonable after they move in, and must be provided to all existing residents at least or reissued to all existing residents at least every 12 months. And there are various provisions as the buildings get higher. There are various other provisions which would kick in. And this is not likely to be a case for individual purchasers, but managing agents on buildings over 11 metres have additional responsibilities in relation to checking of the fire doors at the entrance to each property and fire doors in the communal areas. And if we get into the concept of higher risk buildings, which is buildings over 18 metres, then there are now implied terms in those leases, basically saying that the lease is implied to impose on the landlord the obligations imposed by the Building Safety Act, and also the same implied obligations are imposed on the owners. I'm conscious that we've come to the end of the time, but I'm going to quickly skip through the practice points. In relation to Land Registry change to Practice Guide 9, Land Registry have now basically said that if you are using a power of attorney on a registered transaction, then in addition to the existing provisions of providing certified copy, etc., they're giving you the option to provide a certificate in form Appendix A of Practice Guide 9, which I've set out there on the slide. Now, it's a matter for you, but I wouldn't be personally comfortable to give that certificate. So if somebody asked me for it, I would say, I'm sorry, no, you're going to get a certified copy instead. Of more significance is if you're using a power of attorney where you've got a sale by joint owners. Essentially, if you have a sale by joint owners and you are using a general, an enduring or a lasting power of attorney, the Land Registry have now said that you can use a general, enduring or a lasting power of attorney, provided the power of attorney is dated after the 29th of February 2000, but also they require a written statement from the attorney dated within 3 months of the transfer, confirming that at the time of the transfer, the donor of the power retained a beneficial interest in the property. Now, one of the problems is, of course, the Land Registry have started requesting these for transactions which were lodged some time ago when the 3 months has expired, and so you can't provide a certificate within 3 months because more than 3 months has gone past. To avoid that in future, what's suggested is if you are acting on a transaction where you've got one or more of the sellers represented by an attorney, that you put within the body of the transfer itself a statement from the attorney confirming that at the time the power of attorney was used, the donor of the power retained a beneficial interest. And that would avoid the need for the 3-month statement. So I certainly urge you to, if you're acting on a purchase in that situation, to ensure that it is actually incorporated within the statement, is incorporated within the transfer, rather than actually relying on a separate dated after separate statement made after the transaction. Very small amendment to Practice Guide 67. Basically, if an executor lodges an asset personally, they now need to prove their ID, but that's not exactly going to have much impact on you and I in practice. And then Practice Guide 68 has been updated in relation to Rule 130, which is the clerical error provision. So you can request an amendment to a document under Rule 130 if there is a clerical error. And the Land Registry have basically acknowledged that Rule 130 still exists, but they are making it more difficult to use it. Because they now say that if you want to use Rule 130, then you need to provide evidence showing the mistake and evidence as to how that mistake occurred, and you need to now lodge the consent of all parties where the alteration relates to a non-clerical error. So effectively, it's not going to be as easy to use Rule 130 in future. You're going to need to lodge additional documentation. And the Land Registry have also made it clear that Rule 130 is discretionary, and that the older the document is, the less likely it is that they're going to exercise their discretion. So if it's an older document, then rather, if there's a clerical error in an older document, then you may have no option other than to go for a deed of variation or a replacement deed rather than relying on Rule 130, because the Land Registry have made it clear that their discretion is not as likely to be exercised in relation to an older document. So that brings me to the end of what I want to say. Give now an opportunity to see if there's any questions or observations from anybody who's listening. There's nothing in the Q&A box that I can see, and nobody's raised their hands. So either nobody's really listening, or they've all decided they're completely happy with everything that I've said.
Has anybody got any questions? Time to ask is now. No, it doesn't look like, David. It looks like you've covered everything perfectly. Oh, hang on. Oh, there's one in the Q&A.
Let's have a look.
Oh, there we are.
There we go. If there are 3 lessees on the 14th of February 2022 own the property, and this is the only property they own together, I can't see more. If there are 3 lessees on the 14th of February 2022 who own the property, and this is the only property that they own together, but they have more than 3 other properties in the UK that they own separately, do they class as qualifying? Yeah, that's a very interesting question, Julie. The reality is it's not entirely clear. It's thought in that situation they may not. So if we've got if they own 3 more than if between them, if they own, if one of them owns more than 3 properties, then they may take the others outside the qualifying criteria as well. Unfortunately, however, that is one of the very many issues that is not entirely clear in the Act. My gut reaction is that they will be taken outside of it, but that is simply my instant and gut reaction. I can't point to a section in the Act or anything in the guidance which basically says one way or the other for certain. So sorry, I can't give you a definitive answer to that one.
Okay, thank you. Anybody else before we call it a day? No, I don't think so. Okay. Well, thank you, David. Really interested. Okay. I find some of those bits very interesting from Landmark's perspective, as well as obviously conveyancing transactions. I've been asked to remind you that you'll be sent a link, everybody, to the recording of this session over the next few days. And please don't forget to complete the feedback survey, which will be sent alongside it. This is really important for Surrey Law Society to get this feedback and ensure that they're covering everything that's required. But I certainly think that quite a lot was covered today, David. So thank you very much on behalf of Surrey Law Society, and hopefully all the attendees today.